welcome everybody at this panel on By Fair Means or Full. I'm really honored to be asked as a chair of this panel that is organized by the Ohio State University Moritz College of Law. We have here today panelists of several universities and also private sector. So I will introduce them now. By starting with Damian Clifford, who is a doctoral researcher at the Leuven University. Then, in order of speaking, we have Dennis Hirsch, who is a professor of law, director of the program Data Governance at the Ohio State University and Moritz College of Law, and also a professor at law at Capital University Law School. Then as the third speaker, we have Koene, who is a senior research fellow at the Horizontal Digital Economy Research Institute at the University of Nottingham. And we have Seda of the university. She's a postdoctoral research associate at CITP, Princeton University, and also a FWO fellow at COSIC of the University Leuven. Then we have also Natali Helberger, professor of law at the Institute for Information Law at the Law Faculty of the University of Amsterdam. We have Rosa Barcelo, and she is partner at the law firm Squire, Patton, Boggs. I hope I pronounce it right. And she also is famous for her work at the EDPS.
And then we have our host, Anne-Jel Hoelen from the Ahlstrm.
Yeah, that is the Netherlands Authority for Consumers and Markets. Well, we have a short agenda today. We will start about fundamental rights, and then we will continue on consumer unfairness, first in the European Union, and then we will talk about the concept in the United States. Further on, we will talk about can service providers use consent, and also we will talk about paying with data. Then we will talk about technology. When is it useful to indicate what data entails? So why is this panel so important and this topic so important? Why is the notion of fairness relevant to the governance of data processing? Well, the notion of fairness is of major relevance for it can be the cement between the data protection authorities, the national consumer authorities, national competition authorities, and also between international cooperation. And also because the GDPR doesn't explain what fairness should entail. So what do we see? As consumers authorities, we receive all kinds of signals. We receive signals from consumer associations, from consumers, from the media, from the politicians. And what do we see? We see that traders use misleading wording, privacy-intrusive default settings, giving users the illusion of control, hiding away privacy-friendly options, provide take-it-or-leave-it choices, and choice architecture, where choosing the privacy-friendly option requires more effort for the users. Also, we see online store providers that don't give the opportunity to the providers in their stores to provide clear information on what their software does with the consumer data. This has as an effect, of course, that consumers cannot take informed transactional decisions, and also that it's impossible or very difficult to compete on the characteristics of the product. And that is, a characteristic is data protection and, for example, tracking. We see traders that don't inform consumers on the commercial intent they have. And this is the using of data, for example, for targeted ads. Also, the same traders might promote that their service is and will remain free. Maybe that slogan, well, maybe you've seen that slogan when you created a certain account. These practices have the potential to mislead consumers and or exercise undue influence and might qualify as misleading or aggressive trade practices. These practices cannot all be tackled by the application of the GDPR. I already mentioned that. At the same time, it is clear that there is a more and more pressing need to intervene. In the European Union, we have the consumer acquis, and that is the European harmonized consumer protection rules. One set of these rules is provided by the UCPD, the Unfair Commercial Practices Directive. Well, this directive provides rules that are principle-based, technology neutral, that's very, very important, and also form a kind of safety net. They can be applied next to the special rules, for example, data protection rules. The rules protect the economic interests of the consumers and are based on the principle of fairness. Well, in the European Union, among the consumer protection cooperation network, we talked about applying these rules in data-related consumer problems. You see some recent examples on a pending German case that applied the UCPD on consumer problems of consumers related to data. Also, very recently, in November 2018, our Italian colleagues from the AGCM, they fined Facebook for $10 million, euros that is, for a breach of the UCPD and for misleading and aggressive trade practices. So we see that this concept of unfair and also that is misleading and aggressive trade practices is more and more important in the European Union. So I think this stresses the relevance of this panel.
Okay, I think it's up to me to provide a brief introduction to data protection fairness, or what is construed as fairness within the GDPR, essentially. So what I will introduce is largely based on work that I did with a former colleague and now Natalie's colleague at EVIR, Jeff Auslos. So paper we wrote together, but also other papers that I've written with colleagues and some work I've done myself. So, so the first of these points that I'd like to make is that fairness is actually, it's weird in its construction, or at least it's strange if you look at it in terms of the GDPR and Article 5.1 of the GDPR. So Article 5.1a of the GDPR provides that personal data must be processed lawfully, fairly, in a transparent manner in relation to the data subject. So lawfulness, fairness, and transparency. Now the EDPS has referred to this as three core principles of data protection law. But what's interesting here is it's three distinct principles actually in its construction, because it's actually kind of a weird construction legislatively speaking, because it provides for three principles within actually one provision. If you compare it to the other articles in Article 5.1, so data minimization and purpose limitation, it is kind of unusual in that sense. And that brings me to the two other points that I'm going to spell out in a bit more detail. That basically they are three distinct principles, and what I have in mind is essentially to distinguish fairness from transparency in the first instance, and then discuss how you could delineate fairness from lawfulness in the second instance. And then I've prepared some of the issues that have been bugging me in all the work that I've done in fairness. There's issues that have continuously bugged me about this. So I'm going to end with some questions that I've had in my head for some time that I have not found satisfactory answers to, which I think tie in with the competences of the panel quite well. So for the first one of these, so fairness as distinct from transparency. So there's obviously been this explicit historical connection with fairness and transparency. In the Data Protection Directive, there was no specific transparency principle. However, fairness was continuously mentioned in the same breath as transparency in terms of data collection. But transparency alone does not necessarily make something fair. What I have in mind here are probably two distinctions. So for instance, you also have to provide information at the correct time, or provide it in a timely manner when you're talking about data subject rights. The timing of when you actually provide information is inherently important to the operation of the transparency principle, and just simply being transparent is, I would argue, not really necessarily enough. There's also an element of a burden of care on controllers to take into account the ability of data subjects to actually understand the information that's provided. And we can see that most distinctly in the operation of the conditions for consent in Article 7. So that has led me and Jeff in this paper to question whether it was actually kind of a procedural fairness component within the operation of fairness in the GDPR, that it moves beyond mere transparency. Now, there's also, I suppose, in this regard, a cross-reference to the Unfair Terms Directive, which is contained in Recital 42 of the GDPR, but I'll leave that for now. So then moving on to the fairness as distinct from lawfulness question. So in order to make a distinction here, I think it's important to understand what is meant by lawfulness. And through a systematic analysis or teleological analysis of the GDPR, I think it has a distinct meaning in the regulation, which refers to the conditions for lawful processing in Article 6.1. So it has a narrower meaning in my interpretation of this. So and now we can see through that lens a delineation between fairness and lawfulness when we compare, for instance, the ex ante provision or protection that is provided in Article 6.1f, so that's the legitimate interest balancing ground, versus the ex post balancing that is evident in the right to object, for instance. So that's Article 21 of the GDPR. So, you know, although it's lawful in the first instance to process this information, there's an ex post balancing then afterwards to assess that initial balance that was made. And although it doesn't or it doesn't retrospectively affect the lawfulness of the processing, it's on the basis of fairness that is not being allowed in the future, in my opinion. I realize now that there's some big statements within that, and I'm happy to discuss them, you know, through questions afterwards, or if you want, you can speak to me afterwards, or you can read the paper and then speak to me. But I'd like to move on now, just so I can, you know, elucidate some of the concerns that have been in my head relating to these points. Through what I've described, fairness then acts as an ex ante and ex post system of fairness checks and balances in respect of the Charter. So in respect of what is Article 52.1, the General Limitation Clause. So you set up a system of fairness checks and balances in order to respect the right to data protection and rights and freedoms in general where personal data are processed. And we see a variety of case law assessing not only the data protection framework, but also things like the AVMS directive, etc., where the court has said that where there are conflicting rights and interests, they have to be fairly balanced through the interpretation of the secondary framework. Okay. So we can see that fairness stems from a constitutional level or understanding, and that leads me to, I have 3 points or 3 questions that have been nagging me on this, so I'm going to throw them out. So given that fairness stems from this constitutional level and that the GDPR aims to respect fundamental rights in general where personal data are processed, is there an inherent problem with the fact that some of the machine learning literature focuses on biases as opposed to something broader? So because fairness is broader than mere non-discrimination, so perhaps there's a problem there. The second one is, if fairness is such a vague notion, what differentiates it as a legal principle from data ethics? Now, I don't want to suggest that data ethics is the same as fairness as a legal principle, but simply that there's a lot of confusion there, and I want to question whether fairness could actually be a vehicle for ethical considerations in the context of the GDPR. The final point then that I'd like to make is, given that data protection has a specific mandate through Article 16 of the Treaty of the Functioning of the European Union. I have been really wondering about whether this means the legislator has been essentially given the opportunity to afford a higher level of protection now in comparison to consumer protection per se. So now it has been repeatedly stated in EU law that there's no general competence in relation to fundamental rights, but that's not the same as there being a negative obligation not to interfere with them. But data protection seems to be one of the exceptions here. It has a specific legislative basis to provide protections. So with that in mind, I'm wondering whether we can actually compare fairness in the GDPR with unfairness, because it's unfairness in its construction in consumer protection. So we have the Unfair Commercial Practices Directive, we have the Unfair Terms Directive. Now, it's been suggested by several consumer law experts that consumer protection law at the EU level has lost its protective element. So, like that it's consumer law rather than consumer protection law. And I'm wondering whether data protection has that protective element. I now realize that that's quite a big statement in itself, but it also depends on what jurisdiction you're from. But maximum harmonization, it has been definitely debated. So I want to actually just throw it out there. What's the distinction between fairness and unfairness? And does this potentially stem from constitutional considerations? Thank you.
Big questions. So I think Damian did a great job in explaining what fairness is or could potentially be under the GDPR, and this aspect about ethics is an interesting one because I come back to that as well. And I'm very grateful for the opportunity to talk a bit about what I think is my hobby horse, which is unfair commercial practice. Because I think this could be a very interesting complementary framework, especially when we talk about targeting and data-driven profiling. And I hope to explain you in a few sentences why I think that and hopefully convince you. The first reason Anne-Jel already mentioned, it's a technologically neutral regulatory framework which applies across all sectors, which is already, I think, an important asset. And as Dennis will explain, especially in the US, unfair commercial practice law actually has been at the very source of developing privacy principles. That's probably what you're going to tell us. That is not that in Europe, but even in Europe, privacy has always been also in the background with the Unfair Commercial Practice Directive. Imagine, and part of it is also to protect privacy. Think of doorstep selling, the situation that someone comes into your house, puts his foot in the door and tries to sell you something, and the argument there is, because this isn't the privacy of your house, your defense shield is down, and the person could sell more. Now think of all the applications that you today wear on your body, like the smartwatches and the iPads that try to sell you things in your house. So privacy is inherently also a value that the Unfair Commercial Practice Directive protects. What I find particularly interesting is that the Unfair Commercial Practice Directive approaches fairness a bit from a different perspective than GDPR. Here, because one of the major issues with profiling and targeting consumers, and this whole issue of digital market manipulation, is the need to find a proper balance between the interests of those using the technology to nudge you, to make you do something, and defining this line where you go too far and when it starts creating an imbalance and impinges on your rights as consumer. And that's exactly what the Unfair Commercial Practice Directive is trying to do. So it's trying to create a normative framework with a goal to assess where commercial practices cross that border. And in this regard, it tries to actually get as concrete as possible, which is also interesting. And it offers a number of useful tools in this context. Probably the first thing you think are the information rules. So important provision in unfair commercial practice is you shouldn't mislead the consumer by giving them wrong information or not giving them the information they need to make informed decision. And Anne-Jel already mentioned that some of the consumer organizations are already using that to tackle very cumbersome to read and difficult written privacy policies. So there you already see that it's starting to be an important tool also in the enforcement of privacy issues. fairness under the Unfair Commercial Practice Directive is more than simply dealing with information asymmetries as a potential source of unfairness. There are also rules on aggressive practices that go beyond transparency and are concerned with forms of unfairly exercising pressure or other forms of undue influence on the actual decision-making of us as consumers, but also undue influence on our fundamental rights, such as privacy and autonomy. I'm not sure if you heard about the example of the Australian teens when the same network that Anne-Jel tried to mention actually sell data about Australian teens that in their profiles on Facebook actually indicated that they feel weak, insecure and depressed. So Facebook sold this data to advertisers. My argument would be, in Europe, hopefully this would not be possible because it would be a clear instance of undue influence. Undue influence is defined as exploiting a position of power in relation to consumers and so to apply pressure. And power, of course, is also knowledge, data. So the more we know about these unfortunate Australian teens and their insecurities, the easier it is to target them with products that promise to solve that. So you could argue that this is a situation because of the superior knowledge of a company, knowing where your weak spots are, can be used to actually convince you to do certain commercial transactions that otherwise you would not do, so undue influence. And I think that is a very important consideration in the context of data-driven targeting strategies. The more as our own research shows that majority of consumers believe that personalized measures are more persuasive than normal messages. So this is aggressive practices. And then another interesting tool that the Unfair Commercial Practice Directive has, and GDPR never dared to have, is they simply ban practices that they consider so unfair that they should never ever occur in society. So as part of the directive, we have an annex with certain practices that we simply do not want to see in a marketplace. And one example of such a practice is selling or advertising services as free as long as they are not. For example, a certain service who actually asks you to subscribe in exchange for your data, which is, as we all know, not free. So arguably, that would fall also under unfair commercial practices. Whoa, good. Another reason why I think unfair commercial practices could be a very interesting framework is because when it's discussing fairness also from the perspective of the consumer. So the directive does a rather peculiar distinction between the average consumer and the vulnerable consumer. So it tries to figure out, are there certain types of consumers that are endangered of making not free decisions? Is there a state of powerless or imbalance? Typically, those are the elderly and the children and lunatics. But the interesting question, I think a question that we should start asking ourselves very hard and loud is that new technologies in data-driven targeting could create new vulnerabilities. Take the quantified self, the middle-aged blank user, very active on the internet, typical example of not a vulnerable consumer group normally, but he leaves so much data and there's so much knowledge about him that could be potentially used to apply pressure. So maybe this could be a framework to think of what kind of vulnerabilities data-driven targeting strategies can create. Think of the Australian teens. So these are some reasons why I think it's a very useful framework. Of course, there are also some limitations. For example, one question I'm personally grappling around is with, could we apply this framework also to ideological advertising, political micro-targeting? Because so far this is excluded from the scope of the directive, but it could be potentially an interesting framework. And then also the notions here of fairness are rather vague, with the idea that it's judges that should apply that. So if judges will apply unfair commercial practice law in data issues, they will inevitably need to understand more about also digital markets and data protection. There we come into a third issue. I think we shouldn't underestimate that consumer protection law and data protection law in many respects are still living in two different worlds. with two different sets of regulators. They have, with a very strong sense of their own territory, with different regulatory competences and very different institutional approaches. And I think bridging that difference is an important quest for regulating fairness in digital markets.
Okay, thank you.
Can I add something to that? Because we see more and more initiatives for authorities to work together. We now have also a digital clearinghouse, it's called. That's a cooperation between consumer authorities, data protection authorities, and also competition authorities. And there's also a smaller cooperation between the data protection authorities and the consumer authorities. So I think we're stepping forward.
So, a number of years ago, a subprime credit card company called CompuCredit decided to use predictive analytics to allocate credit among its cardholders. It analyzed their purchase data to see if it could find correlations to people who were likely to default on their credit card debt. And then, once it had identified these proxies, it then used them prospectively where it found its card members purchasing these things. It cut their credit in half. So one of the proxies for high risk of credit card default was purchase of tire retreading services. If your tire is wearing out and you can't afford a new tire, you can get your tire retreaded. Another was purchase of marital counseling or personal counseling services. So if they saw that their cardholders had purchased either of these things, they cut their credit in half. This is an example of a very important new type of data processing, which some call algorithmic adjudications, in which important decisions about our credit, do we get interviewed for jobs? Do we get promotions? Do we get insurance? Et cetera. Do we get marketed certain things or not? We're being adjudicated algorithmically. And those algorithmic adjudications can hurt us. Amazon recently disclosed that they were working on an AI tool to sort through resumes and realized that they had baked into their algorithm the bias in their existing resumes, which was male bias. And so their tool had learned to discriminate against female applicants because the training data was itself biased. So these types of, they caught this apparently and say that they didn't use it. But these types of harms, real harms, can exist in the course of algorithmic adjudications. And traditional privacy law, notice, consent, purpose limitation, doesn't do a good job of protecting people from these types of harms. And the reason is, fundamental reason is, that what's happening in predictive analytics is companies are taking surface data, marital counseling, or you went to a women's college in the Amazon case, and they are inferring latent data that they use to make the decision, like you're a bad credit risk. And when we give the surface data, we can't know what they're going to infer. And so we can't protect ourselves against those inferences. We can't make a meaningful choice. Even if we're given notice, we can't make a meaningful choice because we can't understand it. So I think that these types of algorithmic adjudications and predictive analytics and its increasing role in the economy poses a fundamental problem for privacy law. It means that we need a new type of regulation, one that says, regardless of whether you consented to have your purchases used to determine your credit, which you didn't really know what that was going to mean, was CompuCredit's doing this? Was it something that we as a society feel is appropriate? Does it fit with our values? Was it fair or was it unfair? And this, I think, makes it logical to think about unfairness authority as a way of addressing these value choices, drawing these substantive lines, as I think Natali said. So as you may know, and I've lost my slide somehow, I don't know why. Here we go. Thank you. The Federal Trade Commission, the main privacy regulator under Section 5 of the FTC Act, actually has two authorities. One is deceptiveness authority. That's what they've used the most. Company says something in its notice, it makes a promise about it, what it will or won't do with your data, and then it departs from that. That's deceptive. That's been the basis of the great majority of the FTC's privacy enforcement actions. But it also has the power to declare business practices, including data practices, unfair. And so it could use this consumer unfairness authority to draw substantive lines, to make value choices that will protect people against unfair algorithmic decision-making. So what is this test? How does it work under Section 5? Well, it's a three-part test. The statute sets it out. There has to be substantial injury to the consumers. I think in the CompuCredit case, the fact that people are being denied credit would meet that. Cannot reasonably be avoided by consumers. And I think someone who used marital counseling wouldn't know that they were going to lose credit over that. They can't reasonably avoid it. And in this way, unfairness authority and deceptiveness authority kind of divide the world in two. Like, if you can get notice and understand it and make a meaningful choice, then we should leave the choice up to you, right? The regulator shouldn't make it for you. That's deceptiveness authority. But if you can't understand the choice enough to make a meaningful choice, then giving you control over that choice is just not really giving you anything that you can use to protect yourself. And there, we need social protection instead of individual control, which is what privacy law tends to be about. We need some form of social protection. And unfairness authority can bring that. So that's the main point that I wanted to make, is that in the algorithmic society with algorithmic adjudications that can profoundly affect people's life opportunities, and that traditional privacy law, notice and consent can't protect people, we need a new type of regulation, and unfairness is one way to look at that. And I think that there are some real parallels between the FTC's unfairness authority and the Commercial Unfairness Directive. And I would throw out there, could we come up with a transatlantic approach that would draw substantive lines, regardless of what notice you got, regardless of what choice you got? This is not appropriate in our societies. It's against our values to use data in this way. Could we find some common ground there to make the algorithmic society safe for human beings? I'm going to advance it to your slide.
All right, thank you. So I'll continue along the theme of algorithmic adjudication or algorithmic decision-making, algorithmic selection, call it what you want, the automation of a decision that's going to affect people, and through that, the potential of obfuscating exactly who has responsibility for the outcome and where accountability lies. And I'll be addressing it not so much from the legal framework directly, but rather from the point of view of other activities that are going on within this space, such as, for instance, in the technical community, the efforts to develop some standards around the development of algorithmic systems, but also some work that we've done looking at how people experience their interaction with these services, and what their points of view are regarding the selection of a fair algorithm for a particular kind of application. So the first point, which is sort of the image on the right, on, as Damian mentioned, a lot of the focus within sort of the machine learning or the engineering community around fairness is focused on the question of bias or discrimination. And so within the IEEE, for instance, which is developing some standards that are trying to look at ethical dimensions of these technologies, one of the standards that's being developed is a standard for algorithmic bias considerations, which happens to be the one that I'm chairing. So when we're thinking about how to address the question of bias in the development and the deployment of algorithmic systems, transparency is one aspect. It's do we understand what is going on? But and another important aspect, which is being addressed in an earlier panel today, is around data quality. Do you have a representative data set that properly covers the population that is going to be affected by the system? Have you made sure that when you're evaluating your system against it, that your testing data set properly takes into account different minority groups and makes sure that when you say you've got 90% accuracy, however it is that you measured accuracy, that you're not just saying, well, it's good for that majority population, is actually 100% incorrect for the minority population. But a different aspect around the question about have you built a system that is appropriate for use, isn't being discriminatory, is the question, can you clearly justify what the basis is for the decisions that are being made? And this is something that, especially in the case of machine learning, can become problematic because the actual decision criteria can end up being sort of implicitly introduced into it based on your choice of training data sets as opposed to your explicit definition of the rules. So one of the things that we are aiming for in our standard is that in order to be compliant for this, that you would need to be able to clearly communicate to the people who are being affected by this system what your decision criteria are and also what your justification is for thinking that this is an appropriate decision criteria for the application space for the particular context where it's being used. And this connects to the second part of what I wanted to talk about, which is the choice of fairness. So there's been a lot of work and there's a lot of papers in the computer science literature now looking at how to try and make a fair algorithm, which frequently starts along the lines of saying, in this context, we've defined fairness as being X, such as minimizing difference in disparity in outcomes between different population groups. And then it moves on from that point of view to give a computational way of making sure that that particular definition of fairness is being adhered to. The problem is that fairness is not something where there is a single definition. It very much depends on not just the context, but the values that you have decided to introduce into the system. The small image in the bottom just being one of the glaring ones. Is it equality that you're looking for, or is it equity that you're looking for in the outcomes? And so one question is this just an issue of the particular context where you're applying it? And you can say, well, okay, so in some contexts, this definition of fairness is the right one. In other contexts, this other definition of fairness is the right one. But within a particular context, it is clearly defined. Or is it rather more fuzzy, more something that really is up to a social debate? And so one of the things that we did, we just ran a small experiment with students where we gave them 5 algorithms which all had a particular definition of fairness, and we told them what the definition of fairness was in the different cases. And then we asked them in a particular contexts. So one context was the assignment of an essay task, and the algorithm's going to choose who gets which essay task, and based on a particular criteria of fairness, it would do this allocation. We just asked the students, which algorithm would you prefer to have? And what you're seeing basically in the different bars is how did the different students vote. And it's just a silly little example of the fact that even within a single context, you don't get agreement between students in this case, but if you go to a wider population, you will have the same thing. So the point being, this is really something you can't really expect a company or a particular group of designers to make this decision if it's going to be something that has a significant impact on the population. There needs to be the ability for the impacted population to have a voice, a dialogue around the decision choices. And the final element that I wanted to pick up on is something that we find being reflected in quite a bit of the discussion around fairness, is this argument, well, okay, fairness, but it's a fairness accuracy trade-off. If you introduce fairness, the more that you insist on fairness, well, you're going to end up losing accuracy. And really what I want to highlight here is that there's a fundamental problem with the way that discussion is formulated, because it presents fairness as being something that is unclear. We don't really know which definition of fairness to use. But it presents accuracy as if this is something that is completely predetermined without any values going into it, which is basically nonsense. The choice of how you measure accurate outcomes is a question about which features did you decide are relevant for this case. How do you want to weigh certain different kinds of errors in your system? So really the definition of accuracy is just as much a question of the kinds of values that you're bringing into it as is your definition of fairness. In that case, introducing fairness is basically just introducing one more aspect to your definition of accuracy.
Right, great. Oh, and ooh, okay, all right, so my slides have been re-rendered by Dennis. So I'll just bounce through them and see what happens. Okay, so hello everyone. And I want to start with a kind of misunderstanding that happened that surfaced during our call with all the panelists as a kind of way to motivate what I'm about to say. So my conceptions of fairness, or my interest in fairness in my academic work recently, is because computer science has turned to fairness as a way to respond to discriminatory effects of automated decision-making systems that Ansgar, I think, gave a very nice overview of right now. So when I was contacted, I first thought that this panel was about non-discrimination and different notions of fairness as a way to ensure justice. However, on the call, it became quickly clear that that was a sort of technocentric assumption on my side. And as the panelists, we were invited to bring in different notions of fairness, some related to non-discrimination, but others based on the premise that we should all, regardless of our differences and positions in society, have fair treatment by companies and fair treatment in front of the law. Or at least that's my technocentric interpretation of what I think was expected. Okay, so, but what I want to do is see if there's something constructive to be made of my confusion, what could be seen as an interdisciplinary confusion or an overloaded academics confusion, which is that I think when it comes to current applications of information systems that we are all here to talk about, I cannot imagine a conception of fairness that aspires for equal and better treatment for all, that is not cognizant of the different starting points and life chances among people in the societies we live in. So that's a big, bold claim, but let me just support it a little bit more. So today we have one report after the other showing that the information systems we're talking about have a strong tendency to, one, amplify existing injustices, two, hollow out fundamental rights, three, introduce ways of managing the world which are not always in harmony with democratic principles. We have books written on how privacy, so not fairness, but privacy as a legal right is not equally available to everyone. So especially with the example of the poor or immigrants and other marginalized communities not having much privacy at all. So fairness for everyone is a valuable objective, but if it is the case that our information systems amplify existing injustices and, very important, weaken the institutions that may provide legal protection or mitigate injustices, fairness may be very hard to attain, or as a philosophy may be very insufficient. Especially given that if the legal institutions we have are weakened through these super firms and their technologically defined forms of governance, fairness may just be hard to implement. So I just want to underline that for me, if we're going to talk about fairness, I would like to insist on not losing our sight on our differences with respect to class, race, gender, sexuality, ability, age, religion, migration status, etc. And I would like us to, in general in this conference, talk more about these things instead of calling it discrimination and not talking about it. Okay, so that's point number one. So coming back to where I'm more of an expert and have hopefully less misunderstandings is what I want to talk about next. So the focus of my work is on technical systems and trying to understand whether indeed algorithms or something else is at the center of the reason we have come to talk about fairness in computer science. So why, as computer scientists, are we all of a sudden talking about fairness? Is it really just algorithms? So our current frameworks of algorithmic fairness focus on inputs, so we talk about the data sets, right? Where are they biased, et cetera. The outputs, so who is affected maybe disparately, unfairly, and we claim that these are sufficient to understand the way in which these systems cause injustices. And then as computer scientists, we have developed conferences and events to develop mechanisms to mitigate these kind of unfair results. So the question is the algorithmic fairness the right one? And is it sufficient? And very quickly, if you want to very quickly, my answer is no. All right, so just looking at algorithms, their inputs and outputs, to see if the results are biased or unfair is, in my opinion, utterly insufficient, if not misleading. It focuses on some things and limits our ability to include the interests of the companies and how they drive these algorithms. So instead, I propose that we should widen our analysis to look at the socio-technical systems, I'm going to go for a systems view, that deploy these algorithms in order to manage populations and manipulate environments for profitable outcomes. So I brought in political economy into the picture, which algorithms don't. If we do that, we can evaluate such systems using a framework that assumes that every system that optimizes using machine learning for, if maybe profitable, maybe not always profitable outcomes defined by a few, it will always have risks and costs. So the objective of a framework that we could imagine would be to identify when these risks and costs occur and when they're externalized to people other than those building and benefiting from these systems. And then we can ask if these costs produce unfair outcomes and who should internalize those costs or how we can avoid them in the first place. So I want to quickly give you an example. It's no longer there. Okay, imagine Waze. A company like Waze reroutes its users when there's a congestion on a given path, allowing these users to act with a perfect selfishness. How many of you know what Waze is? Great. So it's kind of like using Google Maps to where you want to go, but if there's traffic, it reroutes you. And it reroutes you, for example, off of the freeway to surface roads. So in some happy universe, this could lead to socially optimal outcomes. But traffic engineers have shown that traffic-beating apps might work for an individual, but they do so at the cost of making congestion worse overall. Waze also often redirects users off major highways through suburban neighborhoods that cannot sustain heavy traffic. While these are useful for the drivers, it affects neighborhoods by making streets busy, noisy, and less safe. Consequently, towns may need to fix and police roads more often. With such systems, even some users may benefit. We see that the costs are incurred massively by non-users and the environments they inhabit. So this is where the ill effects of the optimization systems are not just on the consumers or the users or the data subjects, but those who are living around them. So the example of ways nicely demonstrates the types of externalities optimization systems produce. With machine learning, more and more information systems become optimization systems. Think of systems that enable ride-sharing apps that rely on optimization to decide on the prices of rides. We talked about navigation apps, banks to decide whether to grant a loan, advertising networks to select the best advertisement to show to a user, all driven by an interest in the greatest return on investment. And it is important to note here, Dennis, this is a comment for you, when the credit score decides on did you change your tires or not, it's not because they're making a decision about you personally. They're ranking all of the people and optimizing over them to see how much risk will give them an optimal return. So it's not a decision about you as much as how you rank in the population. And this is something we miss, I think, quite a lot, and we take algorithms very personally. I will have to shut up because we're out of time, but the proposition I would like to make is that if we talk about algorithms and algorithmic discrimination, we focus on the algorithms, we lose the political economy, and we lose the externalities of these systems. And I think if we want to talk about being fair, we need to look at the systems and their costs and risks and who carries the burden. Thank you.
Thank you. Hello, everybody. So my co-panelists have talked about fairness from different angles, data protection, technical. So here I come with a very, very narrow focus to finish this panel. And so I will stay in a very specific situation. And this is the following. I would like to discuss a change sort of view, if we have time, on the fairness of conditioning access to a service to a user consenting to give their data. Looks like very complex, but it's very easy. So can a newspaper tell an individual, you are not going to read the newspaper unless you consent to give us your email address or your website web browsing history. Is this under EU law allowed? Yes or not? So this is the basic question. And why did I propose to come up with this question? And this for a simple answer. I find that the question is like an elephant in the room and is not answered. Legally is certain uncertainty. And depending on where you look like, you get different answers on this question. So, and yet we see it all the time. And something I find that is that sometimes this topic is called cookie walls. It's called, are cookie walls allowed? Can one condition in access to a service to you saying yes to the cookies that everybody sees it? Because what is at the stake is website history tracking. Other times they are called tracking walls. It could be because the data that is being collected is slightly different. But at the end, it all boils down to the same, to the topic of whether personal data can, the access to giving this personal data can be sort of, I don't like to say forced, but whether it is a forced consent. So when you look at that, and for example, you are in the office and there is a client who asks, okay, can we do that, yes or not? And you have to write a memo, and you think, oh, wow, what do I tell them? So the question in Europe is answered in the light of consent, Article 7 of the GDPR. And if you look at Article 7 of the GDPR, it has Article 7.4, it has an article that is quite interesting because it says that when you assess whether consent is freely given, there are several things that one needs to take into account. And it says is whether the provision of the service is made conditional on consent to the processing of personal data. So it does give a certain answer because it kind of nudges you to think, well, is really free consent? And then you keep going and you go to recital 43, And it gives you a little more element also to answer the question. It tells you, well, consent is not freely given if the performance of a contract is dependent on the consent, despite such consent not being necessary. So when you put the two together, you sort of get to the feeling that it might not be allowed to deny access if people have not consented. And in fact, then you say, oh, I got the answer, because you go to the Article 29 board guidelines on consent, and the board said something that was interesting, because it says that tying the provision of a contract or a service to a request for consent to process personal data that are not necessary, it says is highly undesirable. So highly undesirable. So they didn't go all the way to say that it was not valid. So, and here you are, and then you start looking at other elements of this puzzle in order to get a better sense of what you are going to tell this client, that can be a company. And then you see that there are quite a few complaints before the data protection authorities, which have different shades, but they do touch on that topic. There are quite a few that have been made public. To my knowledge, such complaints have not been answered. So maybe soon the data protection authorities, maybe in one of the cross-border cases, will have the chance to give an answer to that. Now, you look at other elements, and there is also an interesting case before the European Court of Justice. It's called Planet 49. It is now already making its way at the end, that it might also give us an answer, but it's still, we don't know. You look at, of course, industry, and industry has alleged and come up with ideas saying that, for example, that if you are not able to require consent, then you basically either operate at a loss because you might not have the data to make money out, or you have to change the business model. You have to sell the information maybe at a price with a subscription, or you have to entirely change. So it's quite of an important change of business models if we go to all the way through. So this is basically where we are, and I guess here we have 1 minute more. In this context, we have other as you mentioned, Anne-Jel, that consumer protection laws have been looking into that from another perspective, but basically reaching sort of the similar ideas. So I think I'll leave it to this. We are at the very end, but maybe there are questions.
Well, first of all, many thanks to all of the panelists for their very interesting presentations. We have 7 or 8 minutes for questions before the man comes and rings a bell at us. So I'd be happy to take questions.
Baron Soka, Tech Freedom. I'm an American lawyer. I'm focused on the Federal Trade Commission and on privacy. So Dennis, thank you for introducing the audience to the powers the Federal Trade Commission has. I think many people, even in the US, don't realize just how powerful unfairness is as a tool. You didn't really get into the question, though, of when it should be used and what should qualify as an injury and how we should make that decision, because, you know, Seda noted that there are lots of things that cause injuries in society. There are lots of externalities, and we, in theory, the FTC could bring unfairness actions against all of those. And indeed, in the 1970s, they did try to regulate a great many things in the name of unfairness, and ultimately our Congress decided that we didn't want to have a second national legislature. We didn't want to have an understanding of unfairness that was so broad that the FTC could use that to regulate any of the kinds of things that she mentioned, that there had to be some constraint. There had to be an establishment of a substantial injury that wasn't outweighed by countervailing benefit. And unfortunately, as you noted, the Commission hasn't really developed that. So I'm curious to hear from you, but also from the Europeans on the table, how should we think about unfairness carefully enough that we can deal with the kind of harms that you mentioned, where we do want the Commission to go out and bring enforcement actions or maybe even make rules, but where we don't want the Commission to, or a European agency to be given essentially carte blanche to go after any practice that they decide it causes more harm than benefit. So I'd like to hear about the U.S. and the European thoughts on that.
Let me answer briefly, and then perhaps one of my European colleagues can speak to it. So I am focusing this on algorithmic adjudications, and there's a reason for that. I'm not saying that's the only area where they should use unfairness authority with respect to data, but I think it's an important area. The controversy over the FTC's use of unfairness authority goes back to the 1970s. And since that time, Congress amended the FTC Act to create the three-pronged test for when to use unfairness that I put on my slide. So substantial injury, not reasonably avoidable by the consumer themselves, and not outweighed by countervailing benefits, which is a kind of a cost-benefit test. And I think there's some important dividing lines there. One of the most important being, if people can avoid the harm themselves through their market decisions, then that is the realm of deceptiveness, right? Then the FTC's role is to make sure that people get accurate information, and they can act to protect themselves. Where people cannot act to protect themselves, because in many cases because they can't understand the information given to them, then deceptiveness authority doesn't really help them. And that's the realm for unfairness. And that's where I think, and that's where I think we are with respect to algorithmic adjudications, which I think are increasingly important to determining people's life opportunities, where I think deceptiveness doesn't help them, and where I think unfairness can play an important role. But let's hear a little bit from the Europeans and how they see the relationship between unfairness and other data protection approaches, including consent and choice and purpose limitation.
Maybe it's good to know that we don't have the same three-step test, but we have something similar. First of all, the authority won't act unless there's harm to the collective interest of consumers. So we won't act on only something that only affects the relation between, for example, a trader and one consumer. Also, the bar that is set for the average consumer is quite high. The standard for the average consumer is a pretty well informed consumer who is quite aware of what's going on, and we can adjust this for certain, more vulnerable consumers. Then, of course, there has to be an effect on the transactional decision of the consumer. So if there's no effect on a transactional decision, so no, for example, it also can have the effect that by misleading advertising, consumer will go to the store. Well, this is an example of a transactional decision, but we have to apply this test. Also, for aggressive practices, it means that there has to be undue influence. And there are some things on the blacklist, but the blacklist is limited. And this means that we only will act without a transactional decision test and without the criteria of the average consumer when the trade practice is on a blacklist. So it's not something that we can apply on every trade practice.
Maybe I'll just add something to this from a data protection perspective, because it kind of goes back to some of the points I was making in terms of the delineation between consumer protection law and data protection law. Because this average consumer test, to my eyes, is it relies on the informed average consumer, and it's quite a high test. When you compare it to the protections that are for the data subject contained in Article 7.4, there seems to be a far more paternalistic approach to the protection of the data subject. in terms of their ability to understand, etc. So that's some of the issues that I was trying to point to in terms of the alignment of consumer protection and data protection. And I think inherent to this is the fact that consumer protection law is an economic protection. So again, when the discussion, I suppose, around the Unfair Commercial Practices Directive is that it's a transactional decision. Data protection law protects both tangible and intangible harms, so not just economic harms. So I think that there's an important delineation there between the scope of both pieces, between data protection framework and the consumer law key. So that's why I find it quite interesting, actually, that consumer protection authorities are pursuing, protective measures or enforcement actions instead of data protection authorities. So I think the Italian Consumer and Competition Law, so the AGCM, and their decision against Facebook actually highlights to me why wasn't the Data Protection Authority doing this? So I'm kind of wondering whether there's actually some institutional funding issues here as well. So is the bigger, better funded national authority the one that's actually pursuing this, and is a lot of political reasons behind this? Because as far as I'm concerned, the protections potentially are higher in consumer protection. So.
May I add to that I would like to add so much more, but what's also very important is that we have the trader in consumer law, and the trader is a broader concept than you could apply in data protection law, I think.
No,
for example, what would app stores be in data protection law?
A controller covers both natural and legal persons, so it covers everyone. So actually, I think a trader becomes extremely difficult in certain contexts. So I think actually it's the reverse.
Right.
Yeah, but the data processing can be, you can prosecute the data protection, the data processor, and sometimes the framework in which the information should be given that is not provided by the data processor.
I think we have evidence that this is a fascinating issue, and people could talk about it. One more round of applause for our panelists, please.